Officer Thomas, good morning to you.
Morning, Your Honor.
Just a quick update on how Guyton is progressing on bond.
So actually, Your Honor, earlier this week, I had sent in a show cause to your courtroom because the defendant had been positive for alcohol at his drug screen he did at the court's drug lab on July 14th.
Okay, well, that's not good. I don't have the show cause unless it's in the file.
I can even forward the email copy I have in Outlook if you would like, Your Honor.
All right, you can do that, please. Attorney Paracano, good morning to you. I do have,
good morning, Your Honor.
Glover here. I'm going to put Glover in breakout room 5. Ms. Glover, your attorney's here. I'm going to put breakout room 5. I don't know if the officer is here or not or yet, but the officer has another 19 minutes to appear.
Thank you, Judge.
Mr. Warling, we're having trouble with getting a Spanish interpreter. So,
Judge, we may have resolved that. I did speak with Corporation Counsel, and I have authority to do this. There was the second ticket, which just had the civils on them. I don't know if the court was comfortable that they would be dismissing the misdemeanors, and I could waive his appearance and just take responsibility for the 2 civil infractions. That's up to the court if you're comfortable with
well,
that.
as long as you can communicate it to him and he's okay.
Yeah, I did through a representative. It looks as though I have the green light to do that.
All right, and that's Gonzalez Martinez.
Yeah, I think that second ticket was the P1730623.
So I have 6231 and 6232.
We were going to plead as responsible as charged, and then the misdemeanor ticket, the agreement was to dismiss that.
I have 3 misdemeanor tickets.
Ooh.
I have a improper plate, unregistered, untitled, and drug license suspended.
Yep. They would dismiss those in exchange for the plea of responsibility.
Of just the one?
He would plead to the no valid registration and the no proof of insurance, and they would dismiss those 3 misdemeanors, Judge.
Pleading as charged to both civil infractions, right?
Correct.
City of Detroit versus Jose Alberto Gonzalez Martinez, case number SP1730615, counts 1, 2, and 3. SP1730623, counts 1 and counts 2. Appearance for the record, please.
Judge, may it please this court, Ben Werbling, P64889, on behalf of Mr. Gonzalez Martinez. He is here, Judge. He's given me authority to plead to the civil infractions with the agreement that those misdemeanors would be dismissed.
Okay, so let's let the record reflect that Mr. Gonzalez Martinez is here. Buenos dias. Can you state your name for the record? Can he understand any English?
I think just a little bit.
Mr. Gonzalez Martinez?
Yeah.
Senior Gonzalez Martinez, can you state your name?
Excuse me?
Can you state your name? ¿Cómo se llama usted?
José Alberto González Martínez.
All right. I'll let the record reflect that he is here, and you said you do have the authority to enter into an agreement on his behalf. You said
I do, Judge.
You said the offer was pleading to the 2 civil infraction and dismissing the misdemeanors.
Correct.
You stipulate the probable cause to the, as an accurate factual basis for those responsible, please?
We do, Your Honor.
You stipulate the probable cause for the dismissal of the other matter.
We do, Your Honor.
All right, I'm gonna find him responsible for for as charged, the no valid registration and the insurance no proof. $50 for the no valid registration, $195 for the insurance no proof. I'll give him 2 weeks to pay. That'll be August the 25th. I'll pay it. Did that kiosk in the city of Detroit. I'm told you can upload the did that. Come on down to the courthouse and pay it in person.
Thank
I
you.
can tell you.
For me to
All right.
spend all that time and all those months and have this thing on.
Say that again.
I was just
Have a
trying to
great
figure out
weekend. Thank you, Your Honor.
where the background.
As well as Martinez. We good?
Yes.
All right, let's go back on the record, Mr. Gala. Mr. Gala, I've given you an opportunity to speak to counsel. Counsel, what does your client want to do?
Your Honor, it appears we have lost him.
No, he hasn't come out.
Oh,
Did you set it up? Do you know? Yeah, let's go back on the record with Mr.
yes,
Gala.
here he
Mr.
is.
Gala, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Go right ahead, Mr. Director.
عم يسأل إنه حكيت مع الموكلك وشو بريد يعمل موكلك ناطر السيد لحتى يجاوب المحامي. انتظر.
Your Honor, we seek a bench trial date.
حضرة القاضي نحن بدنا يوم تاني نرجع فيه أمام القاضي بقضية.
Is he gonna need an attorney?
He is not, Your Honor. He is not. The prosecutor is aware of his situation and he has documents that will clear this matter up for him when he returns.
علمت مدعي العام إنه عنده أوراق لحتى تساعده بس بالتاريخ الثاني رح يكون معه حضرة القاضي.
اوكي.
Is that what you want to do, sir?
هيك بتريد موافق أنت سيد عم يسألك.
انا
ايه موافق مثل ما محامي؟
ايوه.
Yes.
All right, I'm gonna give you a trial date of August the 12th, 2025 at 9 a.m. If there's nothing further, wish you the best of luck. Have a very good rest of your day.
نهار سعيد شهر 8 يوم 12 الساعة 9 الصبح على نفس الطريقة اللي دخلت فيها اليوم.
نفس الميتن ID number نفس الأرقام.
So I come on the same Zoom number that I came on today?
Yes.
نعم. نهار سعيد بقول لك.
إن شاء الله. شكرا يا.
Thank you very much to all.
All right, have a good day, Mr. Rawl. You have a very good day as well as have a good weekend.
Thank you and a good weekend to all.
الحين نروح وأرجع على هذا التاريخ صح؟
Yes, so now I leave and I come back on this date. شهر 8 يوم 12 9 الصبح. تمام؟
اوكي.
Okay. Thank you. اترك الشاشة.
اطلع الحين صح؟
Yes. اطلع.
All right, have a good day. Thank you so much. Mr. Guyton, are you there?
Yes.
Do you have take your scarf off your head if it's not for religious purposes? Do you have an attorney already representing you?
I believe so, yes.
Who was that?
I forget his name. You appointed him to me.
We'll wait on him to come. This is the city of Detroit versus Lloyd, case number SP 1699 9411 SP 17002711. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Lloyd.
Lloyd. Are you there? You have to unmute yourself, sir. He's supposed to be in 336 this morning. Lloyd, can you state your name for the record, please?
Lloyd.
All right, you can see if you can get him an updated offer, Mr. Berry, and we'll enter a not guilty plea on his behalf, give him a $0 bond. See if you can get him an updated offer, but he's supposed to, his file's in 336, but it's just a no insurance proof with an improper display of plate. And no insurance proof with an improper, no insurance misdemeanor with an improper display of plate. Mr. Lloyd, join the breakout room, speak to Mr. Berry. He's gonna get you an updated offer. Keep in mind if you don't like the offer yet. Join the room, please. Let's pass the matter. Let's go back on the record with Mr. Gil. Mr. Gil, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, there's a recommendation to dismiss for compliance.
All right, Mr. Gil, I'm going to dismiss the cases for providing valid documentation. If there's nothing further, sir, I wish you the best of luck. Have a very good rest of your day, okay?
You too, Your Honor. Thank you.
Mr. Dion Griffin, I'm waiting on your lawyer to come we're going to get one on. Has a lawyer ever contacted you?
No.
All right, we're waiting on the lawyer to come in.
Just send the text and another
All right, so as soon as they come in, we'll get you out of here.
I'm gonna go down to 336. And that was for Lloyd, right?
Yeah.
What was the person?
Jonathan Gonzalez, are you there?
Yes.
Do you need an interpreter, sir?
Yes, please. No speak English.
All right.
Thank you.
All right, you're welcome. Ms. Lauderdale,
Yes.
give me the correct pronunciation of your first name again, please.
Algeria.
Algeria. This is the city of Detroit. Algeria, Lauderdale. Case numbers SP 1727641, SP 1727661, counts 1, 2, and 3. SP 1727881, SP 1747881, counts 1, 2, and 3. SP 1747891. Appearance for the record, please.
Sherika Harris on behalf of Ms. Lauderdale. Please state your name for the record.
Algeria Lauderdale.
For purposes of arraignment, my client stands mute.
We'll enter a not guilty plea on your client's behalf. We'll give your client a $0 bond. Ms. Lauderdale, she has some other matters that she recently got. And there are 4 matters on the docket. I counted 9 matters into the record. The one matter that's went along with this case is a disregard a red signal. It's I don't know if it's a default or not, but I would allow her to be heard on that ticket if the city has no objection. And then the other 4 matters are unregistered, untitled, improper plate, no insurance misdemeanor, and license improper. Ms. Lauderdale, Ms. Harris is going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. I'm going to put you in a breakout room with her. Let us know what you want to do when you come out, okay?
Okay, thank you.
You're welcome. Mr. Massaria, good morning to you.
Morning, Judge.
Who's your client?
I'm here on Mariah Lindsay.
Mariah Lindsay is here. Let's see if all the officers have showed up for Mariah Lindsay. I give the officers a few more minutes. I don't have White. A. Williams is here. I don't have Burdick. So White, Jalen White, and Burdick, I don't have. Let's give them a few more minutes. They have until 9:30, okay?
Thank you, Judge.
I can put you in a breakout room with Miss Lindsay. Miss Lindsay, I'm gonna put you in breakout room 6. Good morning to you, and your attorney will come in there and see you, okay? All right, let's go back on the record with Mr. Lloyd. Mr. Lloyd, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, my client seeks dismissal for compliance. He has shown valid insurance and has shown his license appropriately on his vehicle.
Right. I'm going to dismiss the case, Mr. Lloyd, for providing valid documentation. If there's nothing further, sir, I wish you the best of luck. Have a very good rest of your day, all right?
Okay, I appreciate that, and thank you. Y'all have a blessed day too.
You will. You're welcome. All right, Miss Rosalind Green, are you there?
Yes, good morning, Your Honor.
Good morning to you. I need you to turn your camera on, please.
Okay, 1 second.
City of Detroit versus Rosalind Green, case numbers SP 167-9430 counts 1 and counts 2. SP 167-9527 counts 1, 2, and 3. SP 168-0414 counts 1, 2, and 3. And SP 173334441. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Ms. Green.
Rosalind Green.
All right, good morning to you, Ms. Green. Mr. Officer Eason, are you there? All right, Mr. Berry, Ms. Green has another matter. It's an open alcohol in a motor vehicle driver that she's gotten since the time she's been here the last time. I don't know if she wants to keep this separate from these two cases and or get an offer on everything. Ms. Green, I'm going to let you speak to Mr. Berry in a breakout room. Let us know what you want to do when you come out. Today is the date and time set for the trial, and Officer Eason is here.
This Officer Eason is present.
Yes.
And Your Honor, the ticket beginning with 17, I believe it was, is not on the docket.
It's 173334441 as an open alcohol and motor vehicle passenger.
Okay. We're going to the breakout room.
on the telephone at 313-293-4581. Good morning to you. What is your name, please? Telephone 313-293-4581. Hello? Okay, how are you doing there already?
Hello?
You need an interpreter, don't you, Mr. Lopez?
Yeah.
All right, we're waiting on an interpreter. Good morning, Mr. Gilkkey.
Yes.
All right, probation officer Cargill, good morning to you.
Good morning, Your Honor.
Good morning. You're here on Glover?
Yes, sir.
Can you give me an update on how Ms. Glover is doing on bond?
Since our last court hearing, she tested on July 3rd and July 8th. She was negative for everything outside of marijuana. She does have a medical marijuana card. She just reported this morning, I believe, to test today, and we are awaiting for those results.
What are we gonna do with Ms. Glover? Good morning to you, Mr. Farrakhan.
Good morning, Your Honor. Today's the date and time set for trial in this matter, and I don't see either of the three officers having checked in yet.
All right, City of Detroit. All right, thank you, Mr. Cargill. Appreciate you very much. Have a very good weekend. There's nothing further. I don't have anything.
Thank you, Your Honor.
You're welcome. City of Detroit versus Lakeisha Renee Glover, case number Z8095161. Appearance for the record, please.
Joseph Pernicano, P84918, appearing on behalf of Ms. Glover. Ms. Glover, state your full name for the record, please.
You have to unmute yourself, Ms. Glover. I think she might have frozen up.
I think we just lost her. I'll call her and have her log back in, Your Honor.
I think she might call back. She might log back in. I'm sure she's going to.
I'm sorry, Your Honor, I'm back.
That's all right. State your name, Ms. Glover, for the record, please.
Lakeisha Renee Glover.
All right. Today is the date and time set for a trial. I do not see any of the officers that were listed as witnesses that have come in. They haven't come in. So go ahead, Counselor.
Your Honor, this matter was set for trial at 9 a.m. We are prepared to proceed. The officers having failed to check in, and it's now 9:36 a.m. I would motion for a dismissal at this time.
Right. Case dismissed. Ms. Glover, you
Thank you.
dodged the bullet.
Thank you, Your Honor.
Best of luck to you, ma'am. I wish you the very good the rest of your day. All right.
You as well. Thank you.
All right. Anything else, Mr. Fairchild?
Nothing further, Your Honor. Have a great weekend to you and your staff.
Yeah.
I will call you, Ms. Glover, okay?
Okay. Thank you, Mr. Percano.
Yep.
Thank you.
Can I ask if the officers have showed up on Freddie Lee?
I don't see Officer Hoskins.
So we're ready on that one. Yeah, Lee is on the phone.
City of Detroit versus Freddie Lamar Lee, case number SP17. Well, he's got those new matters, Mr. Berry. So, I mean, Mr. Case number V144-31225, V144-31325, V144-31425, V144-31525. Appearance for the record, please.
Aaron Ochering by for Mr. Freddie Lee, P number 69167. Mr. Lee, can you state your full name?
My name is Freddie Lamar Lee, Sr.
Good morning to you, sir.
Morning, Your Honor.
Yeah, so on the case that's scheduled for trial today, we're special requested dismissal. And on the other one, the new case, we're requesting a pretrial date. If the court is not inclined to give a pretrial date on that one, we would just request another bench trial date for the new case.
For purposes of arraignment on those cases, Counselor,
Wait for my reading, stand mute.
you are not guilty plea on your client's behalf. You decline a $0 bond. I'll give him a pretrial. The pretrial date will be August the 4th, 2025 at 9 a.m. If there's nothing further, Mr. Lee, August the 4th at 8:30, I'm sorry, at 8:30 is going to be your next court date, all right?
Yes, Your Honor.
And on the other charges, with those the set for bench trial date, or
I'll grant the motion to dismiss Officer Hoskins. I'll grant the motion to dismiss no officer. I don't see that officer on my list as having been appeared, okay?
All right, thank you, Your Honor. All right, thank you.
All right, have a good day.
You do the same, Your Honor.
Thank you. This is the city of Detroit versus Ronald Gilkkey, case number SP17213191. Appearance for the record, please. Somebody put their appearance for the record for Ronald Gilkkey, please. What's going on? Am I not being heard?
I can hear you, Judge.
Do we not have a
Can
lawyer?
you hear me?
Yeah, I hear you. Okay, I'm jumping the gun a little bit. The lawyers are in the break. Let's give me a minute, Mr. Gill. Are we ready on Lindsay, Mr. Massarella?
Yes, we are.
Sorry.
No worries, Judge.
I need to get it right. All right. She's got a payment plan on a whole lot of tickets here. All right, let's call it City of Detroit versus Mariah Lindsay, case number SP1315639, count 1. 2 and 3. SP 159-30941. SP 168-31061, SP 168-3711, counts 1, 2, and 3. V 11985819, V 11985919. Appearance for the record, please.
Recommend Series P 87848 on behalf of Miss Lindsay. Miss Lindsay, please state your full name for the record.
Mariah Lindsay.
Good morning to you, Ms. Lindsay. Today is the date and time set for a trial. Officer Hendricks, are you there? Officer Hendricks is there. Officer Williams, are you there? Oh, they must be in the breakout room.
Yes, Officer Williams, sorry.
Officer Williams, good morning to you. Can you state your name, badge number, and department, please?
Officer Williams, police officer for the city of Detroit, badge 3410.
Good morning to you.
Good morning.
Officer Hendricks, can you state your name, badge number for the record, please?
Police Officer Hendricks, badge 4342, Detroit Police Department.
All right, good morning to you.
Good morning.
Have you come to a resolution?
Yes, Judge. We'll be accepting the people's offer, which is to 1 count of fail to display and 1 count of improper plates.
No Officer White. Ms. Lindsay, you want to take the deal?
Yes, Your Honor.
Can you raise your right hand, please? Do you swear or affirm to tell the truth, whole truth, nothing but the truth?
Yes.
Or you can put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes.
Do you understand that you have an absolute right to a trial?
Yes.
Mr. Masario went over your other advice or rights in the breakout room, did he not?
Yes.
Did you understand those rights?
Yes.
Do you have any questions about those rights?
No.
You know, by taking this deal, you're gonna give those rights up?
Yes.
Anybody offered you anything other than what's been stated in the record?
No.
Let me draw your attention back to February 23rd, 2025, around 4:42 p.m. in the city of Detroit, in the area of Mack and Connor. Did you have an occasion on that day to come in contact with the Detroit Police Department?
Yes.
Were you operating a motor vehicle?
Yes.
And did the officer ask you to produce a valid driver's license and insurance?
No.
Well, the officer did pull you over, didn't she?
That officer didn't pull me over. A different officer pulled me over.
Different officer pulled you over?
Yes, it was roughly three. It was like 3 or 4 of them. I remember it was a female, it was an African American male, and then the one who was driving who pulled me over, he was a different race. I'm not sure of his race.
But was that officer did you recognize that officer as being one of the officers on the scene?
I haven't seen that officer yet.
This Officer Hendricks. Can you turn your camera on, please? And come into view of the camera, please.
Yes, Your Honor.
It was that, do you recognize that officer as being one of the officers on the scene?
I believe she was the passenger driver. The
Okay,
passenger. Yeah, I was the passenger.
all right, very well. All right, that she can attest to you having the not having a valid license, or that she saw you witness you driving. Then unless counsel has any other objection to that.
I didn't talk to that officer. I only talked to one officer.
Well, I understand that. I understand that. But counsel, do you have any objection to the officer proceeding, or do you have anything to that you want to know for the record at all about that officer not being the officer that Miss Lindsay spoke to?
No objections, Judge.
Miss Lindsay, what's really necessary is, in this case, is if the officer saw you driving the vehicle, and the real pertinent part is to the officer that you actually not having a valid driver's license. So whether they ask you or not, I mean, I'm sure they should have asked you, but whether they ask you or not to present a valid driver's license, the fact that you were driving without a valid license is the most pertinent part. Do you understand that, ma'am?
Yes.
And that officer can attest to her, she would be able to come into court and say that she saw you driving that motor vehicle. Do you understand that?
Yes.
She does not have to be the one he actually spoke to for her to give testimony about what she witnessed with her own eyes. If she did not witness it with her own eyes, then there would be an issue in the court's eyes. But in this case, there's no issue. Do you understand that, Miss Lindsay?
Yes.
All right, was this your motor vehicle you were driving?
Yes.
All right, did you have insurance on that day, ma'am?
No.
All right, I'm gonna find your client guilty of the amended count of improper plate for the no insurance. And I'm gonna find your client guilty of the failure to display for not having a valid driver's license. With stipulation of probable cause, I'll dismiss the other matters.
So stipulated.
B119858819 and B119858919 will be dismissed for no officer. And SP1315639 counts 1, 2, and 3 will be dismissed with no officer. And the other matters will be dismissed for the plea. Ms. Lindsay, I'm only gonna fine you one time on this. It would normally be a $240 fine for each misdemeanor, but I see you're in a payment plan trying to take care of the other matters. So I'll only fine you one $240 fine, okay? We won't fine you on the insurance matter. When can you pay $240? And then if you want to put that as your payment plan, that's fine with me. What I'm going to do is I'm going to give you until August the 12th, and I'm going to mark the file allow payment plan. So either pay it by August the 12th, or come back in here and add that to your payment plan. Understood, ma'am?
Okay.
All right, you have any further questions? I'm gonna waive the warrant fees. Do you have any further questions?
No, that'll be all.
All right, Ms. Lindsay, if there's nothing further, have a very good day. Best of luck to you. Officer Hendricks, be safe, and Officer Williams, be safe. Everybody have a very good day, all right?
Thank you. You as well.
Have a good day, Judge.
Thank you.
And I did let Mr. Whitey know that Guyton is here and told him to zoom in as soon as he can.
Guyton is here, and that's Whitey's client.
That'll be Mr. Whitey's client. Yep.
And let Guyton and let Whitey know that there's an allegation that Guyton did not follow the orders of the court. They said that he tested positive for alcohol.
Okay, I'll let him know.
Very well.
Thank you, Judge. Have a good day.
All right. You as well. Have a good weekend.
You as well.
All right, let's go back on the record with Ms. Lauderdale. Ms. Lauderdale, I've given you an opportunity to speak to counsel. Counsel, what does your client want to do?
Your Honor, I sent a message in the chat, but we are respectfully requesting that we could have someone from Street Outreach come and speak with Ms. Lauderdale.
Very good. All right, Ms. Lauderdale, I'm gonna get somebody in here. Just give me a few minutes, okay?
Okay, thank you.
You're welcome. All right, let's call City of Detroit, Ms. Harris versus Ronald Gilkkey, case number SP 172131991. Appearance for the record, please.
Erica Harris on behalf of Mr. Gilkkey, please state your name. Can you state your name,
Yes.
Mr. Gilkkey?
Ronald Gilkkey.
For purposes of arraignment, my client stands mute.
You're not guilty plea. And
Ronald
your client, give your client a $0 bond. I'm gonna put Mr. Gilkkey in the breakout room. Mr. Gilkkey, Ms. Harris is gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Join the room, please. Let us know what you want to do when you come out, okay? You're not guilty plea on his behalf, give a $0 bond. Let's pass the matter. Let's go back on the record with Ms. Rosalind Green. Ms. Green, I've given you an opportunity to speak to counsel. Counsel, what does your client want to do?
Your Honor, my client would avail herself of the people's current offer, which is to enter a plea to the open alcohol as a passenger, as well as the driving while passenger not on with a seatbelt. It's a seatbelt passenger charge. The remaining matters to be dismissed.
All I see is just seatbelt.
Well, that'll work, Your Honor. That's the other charge.
You want to take the deal, Ms. Green?
Yes, Your Honor.
Can you raise your right hand, please? Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes, Your Honor.
Put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fine?
Yes, Your Honor.
Do you understand that you have an absolute right to a trial?
Yes, Your Honor.
Mr. Berry went over your other advice or rights in the breakout room, did he not?
Yes, Your Honor.
You understood those rights?
Yes, sir. Yes, Your Honor.
Do you have any questions about those rights?
No, Your Honor.
You know by taking the deal, you're gonna give those rights up?
Yes, Your Honor.
Has anybody offered you anything other than what's been stated in the record?
No, Your Honor.
Let me draw your attention back to May the 26th, 2025 at around 2:14 a.m. in the city of Detroit in the area of Shane and East Jefferson. Did you have an occasion on that day to come encounter with the Detroit Police Department?
Yes, Your Honor.
Were you operating a motor vehicle?
No, Your Honor.
Were you in a motor vehicle?
Yes, Your Honor.
And was there alcohol in that motor vehicle?
Yes, Your Honor.
What kind of alcohol was in there, ma'am?
I honestly, I don't, that was a while ago. I don't really remember. I think it was like tequila they were drinking or something like that.
And you knew that it was alcohol in that motor vehicle?
Yes, I actually found out that day that you can get a ticket for that. I was unaware of it.
Okay. The alcohol open?
Yeah, I believe so. I believe so.
You don't know too much. Are you trying to say that you didn't have alcohol?
No, I wasn't drinking. I wasn't drinking that day. I was just in the car with other people that had been drinking. And I didn't know that you can get a ticket for that. I was going to see my friend at her job at the hotel.
And you weren't drinking?
No, I was not drinking that night.
Not that really matters. The law states that you can't be in a motor vehicle with open alcohol in that motor vehicle. I understand the fact that you felt that you didn't really know the law and that you didn't know you couldn't be in that vehicle with that. It is kind of hard to believe that you weren't drinking in that motor vehicle though with them at 2:14 a.m. But you say you're not. I don't have any proof that you were. It's just my gut kind of tells me that you might have had something to drink that night. But that's not where we're here for. Do you want to speak with Mr. Berry again? I don't know if you want to, if she wants to, you know, you just don't seem like you kind of don't seem like you're certain that there was alcohol in that vehicle.
No, I know like they were drinking. So I know that they had, I don't know if it was open because that's where we were coming from. We were going to the store. We were going back to my friend works at the hotel. So we were going to the store to get her liquor. So I don't know if they had open alcohol at that time. So we did go to the liquor store to get her liquor and come back to the hotel room. But I don't know if they had opened it or not by then. I didn't pay attention. I just knew once I seen the lights, I was like, oh my God, here we go again. But I didn't think I was going to get a ticket, honestly. I didn't think I would have gotten a ticket. I didn't know until that day that you can get a ticket for other people drinking in the car.
Officer Eason, good morning to you. Can you state your name, badge number, and department for the record, please?
Yes, sir. Sergeant Easton, badge S668, Detroit Police Department.
All right. What do you want to do, man? What do you want to do? You want to take this plea and admit to them drinking in there and you knew the alcohol was open, or you don't? Ms. Harris put her, seemed like she wanted to chime in and say something.
I did.
Yeah, it did. You came on the camera for a minute, for a second there.
Oh, I came out of the breakout room with the client that I was in and my video was on. I stopped it.
Okay, very good. All right. You want to go back and speak with Mr. Barrett? I can get you, this case is really not a part of what we're doing today. This was just an offer to get a global resolution. This case is something that happened after. This is Officer Eason did not write you for these tickets.
Yeah, I'm like, I have the ticket.
Do you want to go back and speak to Mr. Berry about it? Or do you want to, or we can appoint you an attorney? I guess I'm inclined to go ahead and take the deal if you really want to get it over with. You did admit that there was alcohol in the vehicle. You're saying now that it wasn't open, but were they drinking in the car?
That's what I'm saying. I don't know if they had opened the alcohol after we had left from the liquor store. I did not pay attention to that. So I don't know. I don't know if they opened it then or what it was, but I know we had alcohol in the vehicle for sure. Because we went to the liquor store.
Go back and renegotiate, Mr. Barrett.
Yes, Your Honor.
All right. Rejoin the breakout room, Ms. Green, okay?
Okay.
let's pass the matter. Let's go back on the record with Mr. Gilkkey. Mr. Gilkkey, I've given you an opportunity to speak to counsel. Counsel, what does your client want to do?
Your Honor, we're respectfully requesting a trial date.
Is that what you want to do, Mr. Gilkkey?
Yes.
Come back on August the 12th, 2025 at 9 a.m., sir. If it's nothing further, have a very good day. Best of luck to you, okay?
Thank you.
Thank you. Mr. Griffin, I'm still waiting on that appointed attorney to come in for you. Miss Lauderdale, I will say this, ma'am. To you, we're waiting on Mr. Patel. He usually comes in very quick. So I'll just give you this from me. I do recognize that this may be one of the most challenging times in your life. I will be praying for you to get through this. I do sincerely believe that there is light at the end of the tunnel. And I sincerely believe that if you persevere, that light will get brighter for you as time goes on. I hope that happens sooner rather than later. Do you have kids, ma'am?
Yes, I have 3.
You have 3 kids, so I'll be praying for you. I want you to let Mr. Patel know that as soon as he comes into the room. I do leave you with the quote of Dr. Martin Luther King saying that the true test of a person is not where they sit in times of comfort and convenience. The true test of a person is how they react and where they sit in times of challenges and controversy. So this is your test, ma'am. Why God had to put you through this test, I don't know. I can't answer that. I'm sure he has a reason for everything. But again, I do believe that if you persevere, you will get through this sooner rather than later. And we're going to try to offer you all the resources that we can to help you through it, okay?
Thank you.
You're welcome. If you want to wait in the waiting room, you can. But if you want to sit in the main session, you can as well. That breakout room 5 will be open for you. And when they come from street outreach, we'll get you in there as soon as possible, okay? Mr. Gilkkey, you're all set. You're free to leave. You know your date is on August the 12th at 9 a.m. And then Mr. Lozado, Lopez, Gonzalez, we're waiting on an interpreter.
Okay.
Okay. Good morning, Mr. Pruitt.
Excuse me, Your Honor.
Yes.
Good morning.
Mr. Griffin,
Hello?
go ahead.
Yeah, how long do you think this is gonna take? Cause I'm at work.
I know, I'm trying to get him in here. Can you call again? Does that work?
That's the younger.
Yes.
Okay, call me, just-
As soon as they come in, we'll get you without a lawyer. I could just set this for a trial and let you go. Is this 279-321-1498 still a good number for you?
Yeah,
Are you sure?
yes, I had to think about what you were saying. Yeah, I'm sure.
Is there a better number?
Oh, no, that's good.
279-321-1498. I could set it for a trial and just when the attorney zooms in, we can have them call you today, all right?
All right.
And if he needs something else, you want to do it? Oh, here, oh, no, he's not. If you want to do it that way?
Yeah, we can do it that way.
City of Detroit versus Brian Griffin. I just had deja vu. Case number SP 17028004 counts 1 and counts 2. SP 170285 counts 1 and counts 2. State your name for the record, Mr. Griffin.
Griffin.
All right, today is the date and time set for a pre-trial. I'm just going to go ahead and set this for a trial date on August the 12th, 2025 at 9 a.m. Mr. Griffin, just answer the calls you don't recognize. That call should be that appointed attorney, and it's your email is diongriffin501@icloud.com.
Yeah.
All right, just answer the call, and if you don't hear from that on Monday, zoom back in right quick on Monday to make sure that that you got that attorney, okay?
Okay.
Or I'll have the attorney call us and let us know that he's contacted you, okay?
All right, I appreciate it. I'll answer.
All right, be safe. Have a great rest of your day.
All right, thank you.
You're welcome. For Officer Graves, for Officer Sharp, I'm going to excuse the officers that people have not appeared. Corporal Spidell, you can be excused. O'Donnelly did not appear. Then Leggett did not appear. Lampkin, she did not appear, but that's not for the trial. Mr. Whitey, are you there? He's in the breakout room. All right, are we ready on Green?
Ready, Your Honor.
Let's go back on the record with Ms. Green. Ms. Green, is there anything different here?
Yes, Your Honor. My client stands ready to enter a plea to the seatbelt charge and the charge referred to as driver, that matter ending in 4143. Driving passenger not on a seatbelt. I think that's what it's called.
So 2 seatbelt charges.
The remaining matters to be dismissed, and we set the open alcohol charge for trial.
Does she need an attorney on that?
Yes, Your Honor.
I need a good call number from you, Ms. Green.
313-603-2333.
I'm gonna set it for a pre-trial that the matter SP 173333441. I'll set it for a pre-trial. You want to plead to the 2 seatbelt counts, ma'am?
Yes, sir. Yes, Your Honor.
Stipulate to the face of the ticket as an accurate factual basis for that responsible plea on your client's behalf, counsel.
So stipulated, Your Honor.
Stipulate the probable cause for the dismissal of the other matters.
Yes, Your Honor. So stipulated.
Find your client responsible for the amended counts of, as charged to the seatbelt, you're as a driver not wearing a seatbelt, and having a passenger not having their seatbelt. All right, other matters dismissed, 65 and 65. Pay that by August the 4th, 2025 answer the calls also that you don't recognize. One of those calls should be that appointed attorney, ma'am. If you don't hear from that appointed attorney by August the 4th, then we'll get one appointed to you on the spot. Pay the matter at any DivDat kiosk in the city of Detroit. Opposed, you can upload the DivDat app to your phone or come on down to the courthouse and pay it in person. Those are the two best ways I can tell you to pay at the screen. If it's nothing further, I have a very good day. Best of luck to you, okay?
Thank you so much. For the court date for the I gotta wait for a call for that as well, for the open in the car and the vehicle.
Yes, wait, the attorney should call you. If they don't call you by August the 4th date, we'll get one appointed to you on the spot, okay?
Okay, sounds good.
All right, best
Thank
of
you
luck
so
to
much. Thank you. Have a great day, everybody.
Feel better. All right, Officer Eason, be safe out there. Have a very good weekend. Be safe.
Thank you, sir. You as well.
Come on, go. Take a few minutes break. Call me when the
Mr. Lopez, Mr. Lozada,
Yeah.
Mr. Gonzalez.
Everybody else does. These are, you know, that's a contract you make with the court on bond. You have to follow your contract. Now, that is, do what you're required to do. You didn't show up. So we're in custody. We'll have a hearing when we can. Sure. But we're, gotta get into this murder trial. Okay. All right.
Lady in the jury box with Deanna, she's here. Show us.
Deanna Preston, that's you. We revoked your bond. The warrant is issued for your arrest. You were late. What happened?
Our troubles.
Okay, was there?
His issues with his brakes.
Uh-huh.
He's right there.
We got a virus going around on vehicles. Is there a virus, a vehicle virus? Vehicle virus? Who's your lawyer?
I am your.
Who is?
I am your.
All right, let's pick this up. Come on up. Come on in. Where's Deanna's, Preston's file, please? Deanna Preston's file. Deanna Preston. Okay, we'll go.
Just right here.
Okay, let's see.
Lady.
You have to read that competition, right? You have to read. Announcement shocking.
Yes.
What's the announcement today?
Judge, I'd like to, if we just have a few minutes, I think we're relatively close to getting it resolved, but not quite. It involves a large amount of restitution.
What does that mean? What does that mean? What are you gonna do today? Is what I'm asking.
I'd ask to have the case reset for a short time. We may be able to resolve it if I could talk to Ms. Preston, because there is a large amount of restitution that I want to make sure that she realizes that before.
Okay, this is a year old. This indictment is a year old.
I was unaware of being told.
Just for the record, Your Honor, the offer on the case is restitution for dismissal. So if they do pay the restitution, I'm offering to dismiss this case.
How much is the restitution?
It's about $12,000.
I didn't realize it was quite that much, but.
That's what I emailed it to you.
I'm not disputing that. I'm just saying.
Maybe it's less. Let me double check.
It says 2,500 or more to not less than 30,000. I think.
It's because they had to change the locks because you stole.
Good. Well, Judge,
You know,
again, I think,
what we'll do is, if there's a debate, an issue, we set it for trial and let a jury decide.
Sorry, Your Honor, it was $5,212.
that sounds.
No, all you gotta do is just say, there's a doubt about it, we go to trial, there are no deals. You don't cut deals when there's an issue that a jury can dispose of. That's not the way we do it in this court. If you're gonna say something, stand by what you say. So we're gonna try this thing or not? Let's set it for trial. Is that what we'll do?
Judge, I would rather if the court will give us a very short period of time when we discuss it, because I believe we can possibly.
It's 1 year old. It's about time everybody decided what they were gonna do. 1 week. Okay, set it 1 week. Thank you. Get a resetting. Next, it is Marcus Miles. Marcus Miles. Marcus Miles. Marcus Miles. Is he on?
I don't show him this morning, Judge, but
There's an add-on, says he's gonna be playing, that's what was told, I thought by you.
you know, he was set one time and did not appear because he was in the hospital. I did not know it would reset today, Judge. I believe it's Miles.
Why did we just handwrite, it says defendant to plea, handwritten.
We always hold that judge.
No, I don't dispute that.
Is he here?
Marcus Miles.
He's not even here.
I think it's going to be.
Let me find out how that happened, if we got that added on, he's not even here.
Judge, I can.
He's not on
memory.
Is he on bond or is he?
Bond.
He's on.
Oh, he's on bond. Marcus Miles.
And for court wants.
Marcus Miles, hold on. There's no answer in the courtroom. I asked the bailiff to call into the hall for Marcus Miles, please, in 24 CR 1680.
Judge, I showed it was set next week, I believe, but.
Read out the bottom of that, just so it's the.
Yes, sir. I understand.
See, it says, my coordinator added that on, and they don't just invent
His
it.
finger, I emailed you the docket.
Yeah, no,
And everything.
no, that's the information I had.
And I told the defendant, he's responsible for all films, let them know, we moved 1 week because it was just a sprained finger. That you could come in.
And Judge, I believe he was set next week.
Last week.
Last
Did
week.
1 week because it was just a sprained finger. And you were already here that day and it was just easier to throw it on.
How long got it? Reasonable time. So he was supposed to, was he given notice to be here?
Yes.
All right. There is no answer?
No answer.
All right. Defendant has failed to appear as he was instructed. What was his bond?
6,500.
Did you say 6,000?
6,500.
That's interesting. All right. Defendant has failed to appear and his bond is revoked. A warrant shall be issued for his arrest. His bond is now $13,000. It's double, and he must have a GPS device. And I think we have, is it Brittany Armstrong?
Yes, sir, Brittany Armstrong.
Please. Forward.
Yes, and Brittany is medical.
No. Marcus.
Oh, look, you already gave it to me, sorry. Oh. Those are yours.
And Brittany Armstrong?
Brittany, he's got Brittany here.
Come forward. All right, you're Brittany Armstrong? Well, what are we doing today? This is an announcement today?
Judge, if I could have 5 minutes to talk to Mr. Armstrong, I think the case would probably be resolved. Have a new offer, we can, I think, resolve it. I haven't communicated that to the message here. It's my fault.
Okay. Let me see your driver's license, please. Do you have your driver's license with you? Do you have a driver's license? Let me see it. Thank you very much. You're young. So what's our plan?
Judge, I have a change, a short change on the offer, and I believe that he probably may wish to accept that, but I haven't talked.
Hold on. Attorney, Mr. Burbank, and the state's attorneys. The status of this case at this time, the parties have rested their cases. The court has prepared a proposed jury charge prior to the reading of the charge and the final arguments, which are going to be made shortly here. Have the parties had an opportunity to review the proposed jury charge, any changes or corrections to it? State of Texas.
None, Your Honor.
And defense.
Yes, Your Honor, please court.
Go ahead. God bless you.
At this time, Your Honor, the defense would request that the court include an instruction on self-defense. So that for the jury's consideration. It's based on the facts of the case, that there was a number of shell casings. There were at least two people shooting back and forth at each other. And that I believe that there is some type of evidence that shows that my client possibly or was shooting back, trying to protect himself. So I would ask first for a self-defense instruction.
Okay. State.
Your Honor, there is zero evidence in the record that suggests that Jacoby Rubin did anything that warrants the instruction that they're seeking. And the state does not agree with the submission of a self-defense charge.
All right. Stand by just 1 second. Getting some research data here that was on my desk to refer to.
I have another request if you.
Go ahead. Yeah.
The second thing, Your Honor, is that I would request that an instruction in reference to the lesser included offense of manslaughter be included. This is based on the detective's testimony and questioning, which he said that all shootings were reckless. We had a couple of questions in reference to that, people who shoot guns and things in reference to this incident with a large amount of shots being fired. But he said that any murder should be reckless. Could be reckless, and as such, I would ask that an instruction of manslaughter be included in this charge.
Did you get all that? Okay. Any response from the state?
We're of the opinion that that should be denied as well. There isn't any evidence to suggest a difference in the mental states between reckless and the intentionally or knowingly. The only thing in the evidence is a witness randomly using the word reckless in regards to shooting, but nothing attributed to this defendant, his actions, no means in which any reasonable jury could distinguish that evidence.
Okay.
We're pushing back the wall.
Okay. The definition of reckless is found in section 6.03 of the Texas Penal Code. And in that section, the definitions of the culpable mental states that are used in criminal law are provided, beginning with intentionally, then knowingly, then recklessly, then criminal negligence. And the definition of reckless has a particular definition that is detailed to include a person is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or that the result will occur. And the risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. And that definition consists of 80 words. A word reckless was used by a witness that the defense is relying on, that the officer witness stated he considered it, the actions in his testimony were reckless. There's a good reason why 80 words are used in the definition, because if it would be nice if we could just do it in one word, but it's obvious that the lawgivers, the lawmakers, felt as though they needed 80 words to particularly describe the proper meaning of the word in a culpable mental state. And that has not, the essence of that definition, which was intended by the lawmakers, has not been shown in evidence in this case. And a one-word description by a witness that he considered it a reckless act without more is not sufficient in the record to support that, especially when the evidence shows that the issue of intentionally and or knowingly, as the indictment reads, is arguably based upon the evidence before the jury in their determination. And then the courts, so thus the defendant's request is denied on that. As far as self-defense, the court wants to add into the record its response here. Self-defense also has particular meanings which are described in the Texas Penal Code under subchapter 6, sections 9.31, and then the issue that we have today, deadly force in defense of person. Self-defense using deadly force is in section 9.32. And deadly force in defense of person under section 9.32 of the Texas Code provides a justification by someone to use deadly force against another only under certain circumstances. Number one, if the actor, the person using the asserting self-defense, would have been justified in using force against the other, pursuant to section 9.31, the self-defense instructions in general. And two, when and to the degree the actor reasonably believes the deadly force is immediately necessary to protect the actor against the other's use or attempted use of unlawful deadly force. That's the essence of the relevant language for this particular circumstance. Now, the actors, it further goes, the definition further provides that the person using or asserting deadly force and who believes it is immediately necessary as required in the use of deadly force to defend themselves is presumed to be reasonable if certain circumstances apply, which include, and the person was not otherwise engaged in criminal activity other than a Class C misdemeanor. And furthermore, it provides as well in the definition that a person has a right to be present at the location where deadly force is used and who has not provoked the person against whom the deadly force is used and who has not engaged in criminal activity at the time the deadly force is used is not required to retreat. Those provisions really aren't applicable. Those portions aren't applicable. That is the presumption of reasonableness and the defendant's and any privilege of not requiring to retreat under the law before deadly force. That wouldn't be applicable because it's shown clearly the defendant was committing a crime by unlawfully carrying a weapon when he is a convicted felon at the time that he uses the deadly force. Going back to the use of deadly force, went into the degree the actor reasonably believes the deadly force is immediately necessary to protect the actor against the other's use or attempted use of unlawful deadly force. The victim in this case, what deadly force has been shown that he used?
The state suggests there's none, Judge.
Can the defense articulate in the record where there was proof that deadly force was being used by the victim?
I think it's not clear, Your Honor.
Okay.
Based on, there could be assumptions. One thing though, Judge, I'd like to point out is at this point in time in the trial, there has been no evidence that my client has a prior felony conviction on his record. I know it's semantics, but there has been no proof at this point put into evidence.
Well, I thought that was just discussed off the record then.
Yes.
That was in our charge conference yesterday, but Judge, in fairness, the record is clear that the state has given affirmative notice about his prior felony. Okay. In two different notice provisions.
But it hadn't been proved up.
Not to a jury, no, sir.
All right. Well, then, and those prior convictions really apply to portions within a deadly force usage, which aren't even relevant unless deadly force is applicable. Those are used in failing to retreat and also the presumption of reasonableness by the actor. So we're going to withdraw from the record those findings because the court will find that here the record does not show there's a dearth of evidence that shows that the defendant was shot the victim because of what is required under the statute, that the person being shot, it would have to be shown to be using or attempting to use unlawful deadly force against the defendant. Nothing in the record shows that he was doing anything except standing around getting shot. one other thing is that the court would like to add here. Also, under Lozano versus State, 636 Southwest 3rd 25, a Texas Criminal Appeals decision in 2021, and other cases, without evidence of the defendant's subjective mental state, that is, what the defendant was actually thinking at the time that this occurred, where it's alleged that he took action in self-defense and shot the victim, in this case, killing the victim. A defendant is not entitled to a self-defense instruction without evidence of what his subjective mental state was, which is generally provided by either the defendant's statements or other evidence if a defendant doesn't testify. And there's nothing here that shows what anybody could analyze and discern was his thinking at the time. And as it is cited under certain written law articles, self-defense, it matters when asserting self-defense. It matters for the use of self-defense to be actually presented to the jury of there has to be evidence of what the defendant actually believed, and nothing shows any of that in the record. So the defense requests on those two matters are denied for, among other reasons, what the court has articulated into the record. All right, let's go to the jury instructions. Again, no other objections other than what we have here.
Not
That were presented.
How about the state?
Okay,
From the state, that
fine. How much time?
Two things, Judge.
Go ahead.
Number one is, this time I make an oral motion for a motion in limine. During the voir dire, the state questioned the jury on transfer intent. Transfer intent is not contained in the jury charge. Therefore, I request that the court grant my motion in limine that the state cannot argue transferred intent at this time.
Okay, and the state is agreeing with you. So if that changes, if something changes in the actual occurrence during a final argument, object, and the court will make a proper ruling.
I have one more matter I have to take up, Judge.
Yes, sir.
Stand up for a second. Did you swear, Mr. Angel, in your honor?
Raise your right hand. Do you solemnly swear or affirm any statements you make shall be the truth, the whole truth, and nothing but the truth, so help you God during this hearing?
Yes, sir.
Lower your hand, sir. What is your full name?
Stephen Angel.
And you are the defendant in this case, sir.
Yes, sir.
Go ahead.
Stephen, we are still in our case in chief. We did rest, but we can reopen. But one of the things in the matter is that I want to ask you about is you have an absolute right to testify on your own behalf. You understand that? Yes, sir. And you also have an absolute right not to testify. You understand that? Yes, sir. And if you decide not to testify, as indicated in this proposed and also agreed upon, not agreed upon, but proposed jury charge, the jury is going to be instructed that they cannot consider your silence, your fail, or you not testifying against you when they deliberate. You understand that? Yes, sir. Now, we have talked about this at length, correct? And have you made a decision of whether or not you would like to take the stand and testify on your own behalf?
Yes, sir.
And do you want to do that?
No, sir.
No, sir. Okay. So when you made that decision, was it based on conversations between yourself, between you and me, your attorney? We've talked about it, the pros and the cons, correct?
Yes, sir.
We've gone over the whole case together. And is that what you based your decision on, not to testify?
Yes, sir.
There have been no threats, promises made? No, is that, there's been none made, correct?
No, sir.
And no one has forced you in any way to make this decision. You're doing this freely and voluntarily.
Yes, sir.
Have nothing further to judge.
You're doing it, you're making a decision, you're stating freely and voluntarily and also upon discussions with your attorney.
Yes, sir.
All right. It's so noted and made it part of the record. Anything else?
From defense.
All right, please bring the jury in. Thank you.
Can I ask you to pause?
Hold on, Dennis, just 1 second.
I just want to get this information moving forward very much.
Okay, we'll bring them in, then I'll ask the parties if there's any additional evidence to be presented. And then we'll move from there. Mr. Ham, would you be so kind? Can you do what you do so well?
Yeah, sure. Tell me which direction, check.
Counterclockwise? Right.
Counterclock, that's going this way.
Yes, sir. A little more. Just a fraction. Yeah, it came back just a second.
It kind of jumped on me just. A little bit more, all right? I feel like we're moving furniture.
Stop. That's good. And the lectern just comes back 6 inches.
No,
And it'll
we're
be
gonna
turned-
turn it this way,
It'll be
Judge.
turned as well, which probably ought to
Tell me when you
back
Back
6
this up.
inches back toward you. Good.
You sure?
I'm pretty sure.
It's crowding me. Yes.
Always done that. Okay. Everybody ready?
I thought, hang on, just needed this one last thing.
How much time are y'all asking for? If you get to 20 minutes, I'm going to alert you. You have a reasonable amount of time.
You know, connect this.
Hey, did you read that fine law article that was provided to you?
I did, and I asked a member of my household to get a frame like the Declaration of Independence so that it could be prominently placed within my
That's what everybody's doing.
residential dwelling.
That's what everybody's
So
doing.
when I wake up in the morning to put a suit on, to come to a court of law,
You're presuming the right thing.
presumption of innocence.
You didn't disagree, I don't think, with any of that.
It's
did
my new motto, Your Honor,
you?
for life.
Little historical stuff there.
It's very, yeah, I mean,
And I wrote one on Beyond a Reasonable Doubt that was published in the judges.
Context or viewpoint?
In the judges they have a annual, a monthly. Or it's quarterly. Issue of law articles and things like that, and that was a few years ago, and that turned out interesting, pretty good. It was interesting that the Stefan, Rayon, and Gil, who was present with his attorney and the state's attorneys. When we rested yesterday, the parties had announced they rested their cases. Do the parties request reopening for any reason at this time? State?
Judge, I don't, but I do believe I need to tell the court that I don't intend to present any state's rebuttal. So we affirmatively rest.
All right, defense.
We have rested, Your Honor.
All right, ladies and gentlemen, the parties have rested their cases. The evidence is before you, and at this time, I'm going to read to you the jury charge, which contains all of the law necessary for your deliberations in this case. In continuing to discharge your responsibilities as jurors, you must continue to observe all the instructions the court has given to you. These instructions are given to you, and they're very important because your conduct is subject to review the same as that of the witnesses, parties, attorneys, and myself. Please listen carefully, as I know you will, as I read this charge to you. The original here will be left with the jury to refer to as necessary during your deliberations. Members of the jury, the defendant stands charged by indictment with the offense of murder, alleged to have been committed in Jefferson County, Texas, on or about December 27th, 2021. The defendant has entered a plea of not guilty to this indictment. Our law requires that I submit the following charge to you in this case. This charge contains all of the law necessary to enable you to reach a verdict. If any evidence was presented to raise an issue, the law on that issue must be provided. Definitions. So that you can better understand some of the words and the terms used in the charge, the law provides the following definitions. Murder. A person commits the offense of murder if he intentionally or knowingly causes the death of an individual. Intentionally. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. Knowingly. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Deadly weapon. Deadly weapon means one, a firearm, or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury. Or two, anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using energy generated by an explosion or burning substance, or any device readily convertible to that use. Bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death. Serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. Prior conviction affecting credibility. In this case, evidence has been introduced that one or more witnesses who testified may have previously been convicted of criminal offenses. The law permits this evidence to be introduced only for the purpose of aiding you, if it does, for determination and passing upon the credibility of the witnesses, and you cannot consider this evidence for any other purpose. Defendant's election not to testify. Our law provides that a defendant may testify in his own behalf if he elects to do so. And this is a right given to a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer to or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. Charge. Now, if you believe from the evidence beyond a reasonable doubt that in Jefferson County, Texas, on or about December 27th, 2021, the defendant, Stefan Rayon and Gil, did then and there intentionally or knowingly cause the death of an individual, namely Jacoby Joan Rubin, hereafter styled the complainant, by shooting complainant with a deadly weapon, to wit, a firearm, you shall find the defendant guilty of the offense of murder, unless you so find, or if you have a reasonable doubt thereof, you shall find the defendant not guilty. Stand by. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense or offenses is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. And the law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt, after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. You have a right to consider all of the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are in the case. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. And you must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for any juror to discuss or consider anything which they know or have learned outside of the testimony presented to you and the law contained in this charge. If a juror should discover that they have any outside information, they must not mention this information to any other juror, nor consider it themselves in arriving at a verdict. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. And you must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question about the law develops during your deliberation, it must be reduced to writing and signed by your foreperson and then given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Any physical exhibits that have been admitted into evidence will be furnished to you upon your request by the bailiff. After the attorneys present their arguments to you, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during your evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict or verdicts attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case in accordance with the law and the evidence. And we have two verdict forms, ladies and gentlemen. One, we, the jury, find the defendant guilty of the offense of murder as charged in the indictment, a place for the foreperson to sign, and the other, We, the jury, find the defendant not guilty of the offense of murder as charged in the indictment. A place for the fourth person to sign. Under the
Short second.
You can say that. This one has 21 on it, Judge. The other one had 2010.
Thanks. All right, under the rules, the state of Texas may open and close final arguments. What says the state?
You're on the open. Good morning. Thank you all for your patience this week. I specifically want to thank you for giving me some extra time Tuesday afternoon. I had two particular witnesses that could not be here Wednesday, and I know I imposed on you all. And I didn't have the chance to say that, but I'm going to say it now. Thank you. I don't normally give an opening statement. I usually reserve all my comments till the end. But I think with this particular case, I want to get you guys focused in on your job, and I know you're ready to do your job.
Hold on for just a second. I'm sorry.
Yes, sir.
Let me see the long stuff here.
Death of Jacoby Jawan Rubin. And did that occur by shooting him with a firearm? Folks, all those elements really were uncontested. There was no disagreement that Jacoby died that day, that he died by being shot with a firearm right here in Jefferson County, Texas on that date. We heard a ton of evidence about what Charles Nicholas did. We don't see his name up there. We heard a ton of evidence about what all these other people did and who all got there. And that's just getting to what one of the witnesses actually said, we can get into the weeds. That was the doctor that said that. It's a lot of what we did this week. But the bottom line is, ask yourself this. Is there anything that suggests anything other than proof of those elements beyond a reasonable doubt?
I'm sorry, I'm going to have to change. You're referring to that, and that's
Thank you, Judge.
incorrect.
My judge is really great about this, and y'all probably already know where he's heading.
Yeah.
It's that word and
The statute provides that the state of Texas can charge in the conjunctive and intentionally and knowingly. But the statute reads by the legislature intentionally or knowing. So the disjunctive is what you must consider. They're allowed to, and it's been a historical practice to include the conjunctive usage in the indictment, but the jury needs to understand and instruct intentionally or knowingly can be proven in the disjunctive, either one or both, or what the test will be in a murder charge. Does everybody understand? Okay, thank you for saying. Hate to make it confusing, and I'd like yours to cut through some of this confusion. Thank you for bearing with us.
Thank you, Judge. Eventually, I'm going to correct that slide, correct? All right. So I'm gonna say, anticipating what I'm gonna tell you, I pulled out the sheet that defines knowingly. I'm gonna read it to you. I don't know who's gonna end up being the foreman, but I'm asking whoever the foreman is, pull this out and get started and read it. Again, I'm gonna read it to you one more time because I believe this is the proof that's just substantially right there staring us all square in the eye. A person acts knowingly or with knowledge with respect to result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Example, if I pick up a gun and I pull a trigger, I can reasonably expect it's going to hit somebody and can cause their death. That's what knowingly means. And that's what happened. Now let's hear if the defense can refute that.
There, please, court.
Yes, sir.
Thank you for the introduction. I again will, as Mr. Ham did, thank you very much, ladies and gentlemen, and thank you for your time. When we started this Monday afternoon in voir dire, there were a couple of things that you told me that y'all were gonna do, and I'm gonna hold you to it. One is that you were gonna listen to all the evidence and take in all the testimony, and not all the evidence and listen to the testimony. And then take the jury charge, which was just read to you, follow the law, go back there and make a decision. And I'm gonna hold you to it. And I want you to. If it was, can I have the overhead, please, so I don't ruin your, thank you. If it was that easy just to say, here are the elements, and that's it, we wouldn't be up here standing arguing. But it's not. And I would submit to you, and I don't think there's an attorney around that would disagree, never know. But a case is made up of totality of facts and circumstances. So the question comes down, because we have video, the question comes down to whether or not Stefan, whoops, oh, I'm sorry, shot and killed Mr. Rubin. What's going to come down to? And if you agree with that, whether or not he intentionally or knowingly did that act. And that has to be in such a convincing fashion or level that is proven beyond a reasonable doubt. And you took an oath for that, because this is extremely important. There are no parties that have won here. You have a dead person and you have an individual that could spend the rest of his life in the penitentiary. And what I say and what Mr. Ham says is not evidence. It only is what I think are important points. And I would believe that's what he's going to say too, saying, look, jury, over this week, this is what we saw. This is what we heard. This is what we observed. And this is where I think is relevant in reference to this. The other thing I want to talk to you about is that one, all these individuals grew up together. They weren't strangers. They had disagreements. They lived maybe a different culture, but that's just the way they were brought up, right or wrong. Okay? They weren't probably brought up with white sheets and on their bed and meals at 6 o'clock in the evening and things like that. They lived down the streets. So we know, starting off, what we heard is there was a disagreement. Now, who started it and what it was all about? It was on Instagram. But how were they going to settle that disagreement? And how they were going to settle it was with a fist fight. Now, rest assured, there are probably a lot of individuals in this area that carry guns that probably shouldn't, but that's just a fact of life. Okay? They do, and they shouldn't, but it's there. And it goes to that culture in which they're brought up in, right or wrong. So what do? Because they know each other. We're gonna meet at Gillum Circle. We're gonna fight. So they all get in their cars and they want to see a fist fight. They realize they can't do it there because it's public, private, police are there or not there or may show up. They decide, let's go back to where we grew up, which was 11th and Liberty. And let's go fight. You've seen the video how many times? You know. And so they all come and they all get in their cars and they show up. You see anybody with a gun at that time? Do you see anybody get out with a gun at that time? Well, you have some evidence that maybe somebody that testified had a gun, and he admitted he had a gun. But for the most part, no one did. The fight was on. And as you see in the back of the video, Stefan and Jacoby start fighting. And what you hear in the testimony is that Stefan probably got the better of Jacoby. And that probably would account for when the pathologist said that Jacoby had some bruisings in the mouth, in the eye, probably the scrapes on the roadway. Some of them probably were from the fight. Okay. And the fight was over. But it wasn't. Because what you have is an intervening force. And that's Charles Nichols, the half-brother of Jacoby. And what did he do and what did he tell you? Well, he thought that Stefan was going to go or coming towards him. But I would submit to you of what I heard from Mr. Nichols was, this all started with me. There were some words said on Instagram. It's really started with me, and I don't know why Jacoby got into the fight on this. But knowing that, and even with Mr. Nichols saying, Charles Nichols saying, got the better of him, what did he do? They knew I had a gun. I took it out. Now, if you want to believe that he just bladed it or kept it by his side, we provided people that were there, and you got to judge the credibility, but they were there, that said, you pointed it at Stefan. I ain't fighting. Oh no, I got a gun. Doesn't that make sense? Reason and common sense, because that's what we asked you to do. And you know why that probably makes sense? Is because when you see in the video, they're not running to move their cars for the garbage truck. They're moving it because everyone around there knows what's going to happen next. Someone's pulled out a gun, pointed a gun, didn't keep it in his pocket, didn't keep it down here. I ain't going to fight like that, or I'm not fighting. So what does everybody do? It's in the video. They run. They run. You see Stefan. He runs back to the car. You see him get a gun. Right? It's in the video. But when he walked back from the car, did you see him pointing it up at anywhere? Did you see him going after Jacoby or Charles? Well, he walked towards there and got to the front of Charles' car, the red one, and stops. He didn't raise the gun up then to say, I got a clear shot now. I got both of y'all. You want to play with the gun? I'm going to do it now. What does he do? He walks around the car and he goes back to the rear tire and shoots it. Bang. Now, everyone's standing around. Everyone starts running like, whoa, wait a minute, what's going on? But what are you seeing then in the video? You see Stefan, after he shoots the car, walks back to his car. He wasn't running. He wasn't looking around. He was gone. He went back to his car. There were no other shots at that point. Something happened, that I've submitted to you, that when he got to his car, that's the reason why he turned around, raised his gun, and shot. Now, what could that be? Using your reason and common sense and what you heard from the stand here. I submit to you that once the shot happened, Charles started or was going to start shooting because everyone heard the shot. Because what did we hear? Even from Charles, my brothers came towards me and tried to get the gun away from me. If he wasn't in a threatening manner, if he wasn't about to use the gun, why would they ever want to take the gun away from him? Why? You heard it from Charles. You heard it from one of the witnesses that I produced, Mr. Thomas. Why then, if he was not threatened, they wanted to take it away? Because he left. He was getting back in his car. But I submit to you that in the struggle, that Charles started to shoot. He started to shoot. That's when he stopped and said, oh, they're shooting at me. I'm going to start shooting back. And it's during that struggle, I'll submit to you that probably Jacoby got shot. Now you're going to say, how did I figure that one out? You don't see the struggle in the video. You heard Charles. Both of them came up. You didn't see that in there. But one of the things, and you remember my questioning to the pathologist, the bullet wound on Jacoby. Where did it go in? Went in the right side. Where did it come out? Came out his neck. Would you agree with me? 45-degree angle? Yep. Give or take a couple of degrees? Absolutely. So when you look at that, and you look at the time that Stefan shoots, you also have to take a look at that video to find out what's in his way and how he shot. There were 3 cars in his way, or 2 cars in his way, all right, because you know they were behind or in front of the white Tahoe. There were bushes and trees, and he was across the street in the intersection, pointing straight. We know that Jacoby is 5'8", maybe. That's what's on the autopsy report. 5'8". And we know that the bullet came in, had to be somewhere around a 45-degree angle coming up. Remember I asked the detective? Because he went through, if I hit something at, 2 miles or whatever it is. You expect that whatever this distance was, it would be accurate. Yep, would. Be some deviation, but had to be accurate. Proof beyond a reasonable doubt. We know that the other shots that happened then, in reference to Charles, he starts shooting. He's in the middle of the street. He's in front of the white car, and this is State's Exhibit number 5. He's in front of the white car. He's over on this side. We know there's a ditch here where everything is in reference to the shots. Let me add something else. You've heard evidence, and they've made a big deal in reference to presenting evidence from witnesses. This is Charles' weapon. This is Charles' clip magazine. Capacity is 17 rounds, or in the chamber makes 18. There was 1 left in the chamber. So that means 16, 1 in the chamber, 17. They recovered 12. Where are the other ones? I submit to you because I asked the detective, and the reason why I asked for him. In the pictures, you see detectives combing through the grass. I asked whether or not they used a metal detector, to make sure they got all of the casings. And he said no. I submit to you that Charles probably might have had that gun at capacity. They just never found the other shells because they were either kicked, run over, because we knew there were 4 or 5 of them that had been run over because of the crimping. Or they were still out there in the grass. Remember, I went over that, reference to the different colors and stuff like that. Proof beyond a reasonable doubt. The other thing I want to bring up, ladies and gentlemen, is that during this video, and you're going to see a lot of this video in about a couple minutes. Not from me. But a lot of this, at the end, you see the white Tahoe that we know is Chan Rubens. There was some type of testimony that says he was rushing to the hospital. That was what the excuse will be, or what the reasoning is of why he had to get out of there so fast. Play the whole video. Because at the time he sped off and didn't want to get stopped and didn't want to be there before the cops, his brother was still laying on Thomas Boulevard dying. You know that because the officer that chased him down 11th Street had to call it off and went back to Thomas Boulevard and gave aid to his brother on the side of the road as Jalen Thomas held him, saying, please help him. So he wasn't trying to get to the hospital. He was going there for some reason or to hide something, I would submit to you. Or he took something away from the scene. Why would you leave your brother dying on the side of Thomas Boulevard? If you take the totality of the circumstances, ladies and gentlemen, everything, I ask you to take a look at everything and consider everything to the point of beyond a reasonable doubt. There is doubt. And I'll leave you with this one thing. During this week, the state made an exceptional effort to tell you and made the witnesses say, look at that video and look at that time. And when they said the time, no, I want you to go to the second. Remember that number of times? 12:52, 12:53 in some seconds. If you want to take that as correct, please go to State's Exhibit number 50, the hospital video. Because when Mr. Commander was up there, do you know what time was on that video? 12:50. And he said that was accurate. So which one was accurate when you're gonna either a home video thing or a hospital, or do we really know whether or not those times are accurate or not? And here it says 12:50 in front of the hospital. For Mr. Commander. So when you look at that in a minute, and he's gonna go and split the screen and everything else. I guess they were at the hospital before it happened. Well, that's what this video says, the time. Well, who knows what the time is? And that's State's Exhibit 50. Bottom line to this, ladies and gentlemen, it's a terrible thing. That's what has happened. Someone has died. They were friends or at least acquaintances. They all acted alone, and they thought they were just going to settle a fight, as usually a lot of people do in reference to a fist fight, and everybody goes home and they come back another day. We know that Charles was out of control because he's testified that his adrenaline was such that he doesn't remember what he said or what he did and couldn't remember. You can remember his testimony right there, and you can ask for the judge to get it back to you. And during that moment, when his two brothers tried to wrestle the gun against, from him. I submit to you that it was when he shot the tire out of the car that Charles became incensed of what he was doing and started shooting. And during that time, either it hit the ground or the way it was, that's the only person that could have hit Jacoby. Just by the angle itself, 45 degrees coming up. On the very last page, one of them before the verdict form, ladies and gentlemen, there's an instruction. And I always thought it's the most important, and everyone's heard it if you do this long enough, and I've been doing it since 1990. It says in paragraph 8, in returning your verdict or verdicts, it is your responsibility to make certain that justice is done in this case in accordance with the law and the evidence, and you're going to receive it. I asked you Monday whether or not anybody would have a problem doing the right thing if they did not prove beyond a reasonable doubt the elements. And you all said that you would. This is what we asked you to do. Good, bad, guilty or not guilty. Make a decision because we couldn't. And I trust that you all will. Thank you again for your time. This is the last time I get to talk to you. If I forgot about something or I didn't explain something to you and it's shown after Mr. Ham now gets up, why didn't we hear this or hear that? Blame me. I'm Stefan's attorney and his freedom's in my hand. Thank you.
State of Texas, please.
I shared with you all that I don't normally give an opening. I'm glad I did this time because I got to be calm, cool, and reflective. I'm trying to gather myself after hearing that closing argument. So in gathering myself, best way to do that is for me not to get emotional about it and lean in on what the judge tells you in his charge. Okay? Doesn't matter what Tom says, doesn't matter what I say. Mr. Burbank and I are attorneys. Our questions and our comments do not constitute testimony and must not be considered as evidence. Evidence comes from this table right here and what came from that chair. That's the evidence. Next thing, you must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. In other words, if I say something that's not in the law that the judge gave you, I say some obscure thing and you go, gosh, you can't go along with it. Same thing is true for him. I challenged the defense when they got up here to give you any reason to believe that the elements were not proven beyond a reasonable doubt. It was real clear what I said as I sat down. The suggestion from defense counsel was that in these courtrooms, it's not about the elements. That you have to consider the totality of the circumstances is what his words were. On this big screen, I've got the court's law to you. Not what I say, this is what the judge says. The prosecution has the burden of proving the defendant guilty and it must do so. And he tells me how. By proving each and every element of the offense charged beyond a reasonable doubt. And if I fail, you must acquit the defendant. You must. If I don't do my job, if I don't pass that, we grade my papers. If I fail, I expect you to acquit him. Nothing in this charge says that you're supposed to look at all the totality of the circumstances in making that decision. Yes, you consider the evidence, but the judge gives you the parameters. You do it by looking, is there proof about the elements of the offense? I submit to you it's overwhelming. We talked on Monday about some of the ways in which that can be shifted, and we talked about self-defense. Remember? We talked about if somebody kills somebody, is it justified? You would have gotten a whole set of instructions about that if there was any kind of evidence that raised that. There's no instructions about self-defense because this killing is not justified. The suggestion that you consider the totality of circumstances goes back to this instruction from the court. You must disregard any statement of the attorneys that is inconsistent with the law contained in the charge. His suggestion to you is that Charles Nicholas, and let's get his name right, it's Nicholas, Nicholas, that his conduct is the cause of this. He's not on trial. Chan Rubin is not on trial. Stefan Angel shot and killed Jacoby Rubin. Nobody else. Why on earth would we shift the blame to somebody who's not charged? This is what gets me so upset. But I'm leaning in on this instruction. I don't fault Mr. Burbank. I've sat in that chair for years, as I've talked with you all about. And it is difficult when the evidence is overwhelming. It is difficult when you can't get someone to accept responsibility and stand in front of somebody and move forward. But I will never fault a defendant for asking me to come in here in the courtroom and to do my job and to prove that case beyond a reasonable doubt to you. That's why we're here. So let's deal with the last little curveball that is thrown. It is suggested that you look at this hospital video and the time mark is up there and whether or not those things are accurate. I think you guys have paid enough attention. By the way, I'm not showing the videos. You've seen them enough. But for my note takers, I'll remind you about some of the times. And again, I saw y'all taking notes, and I really 100% appreciate all the attention you've given this. The time's important because I'm synchronizing the two videos. The time's important because of what we're looking at. And again, it's all the conduct of this man right here. At 1:52:19, the time demarked on these videos is when he shoots the tire. Detective Cousins does a great job of telling you when he's reviewing all that, he's watching the people. And we watched them, and we watched them, and we watched them. Nobody between these two time frames, here and the next one of 1:52:53, reacted like anybody shot a gun. That is key, because that's the argument that they're making, is that Nicholas shot a gun, and that's why all this happened. Common sense tells you entirely different from that. I went frame by frame painfully for you multiple times so that you could see him holding the gun up at 1:52:53, see that puff of smoke, and then at 1:52:54, see Mr. Rubin fall down. We got into a whole discussion about, was there any blood there? Well, of course there is. That's why I brought you the video to show you that. Matches the blood trail. And then he goes all the way over there and he dies. So the big thing when we do with the doctor about the direction of he gets shot under here and it comes out here. I don't know how he was standing. He could have been standing like this. He probably wasn't facing the man that shot and killed him. But he was forcefully thrown to the ground and had to try to get away. What on earth did Jacoby Rubin do to die? Not a thing. Not a thing. These times here was when the defense suggested that we look at all that. That is when there's obviously some shooting going back and forth after this man shot. They suggest that they're running there. They even played the Where's Waldo game with all the other folks. You help me shit to my PowerPoint. It's no wonder I lose sleep at night. Can't get past my own notes here about who really is on trial here. Those elements. Get back on track. That man right there, on that day, in this county, your county, knowing caused the death of Jacoby Rubin by shooting him with a firearm, which we don't have. I pause like that because the other guy that keep fussing about, he freely gave his gun. Now we're supposed to speculate whether or not it was full or not of its bullets. Come on. Come on. Every bullet that came from this match is a Hornady. Just like a lawful gun owner would have. A gun, all the matching bullets, good to go. That whole 9mm, that's gang thug type activity. That's the truth, y'all. I want you to follow the truth. Not all those weeds that we were talking about. All the state's asking you to do is to consider and follow the evidence. Because it all supports the elements. Your common sense is what I want you to use. Again, I've been in Mr. Burbank's chair before. I understand what a daunting task this is. And he has to distract you. He has to confuse you by muddying up the waters, getting you distracted by not pronouncing people's names right, getting all caught up in different little legal issues or factual issues that don't make a difference. But just like Dr. McLean says, we don't really want to get caught up in the weeds. You know, it's that whole explanation he was talking about when he was being questioned about marijuana in Mr. Rubin's system. That had nothing to do with whether or not he died that day. Nothing. Just a form of discrediting. Let's talk about him using drugs. Let's talk bad about his brothers because this man let him die that day. Those are all the witnesses that you've heard. Mr. Angel's up there. Got any question about all that? State's Exhibit 71. He's being interviewed about that wound on his foot. Remember how none of it, not a single word out of this man's mouth matches anything that we've been talking about today. If he was saying, I did all that because they were shooting at me, that's a common sense thing. You all would have said that. If you were laid there in the hospital and somebody pulled out a gun and started shooting at you and you got shot in the foot, you would tell the officers that. And you would tell them that you want him prosecuted. This guy didn't even want his picture taken. Wonder why. Remember that, don't take my picture. Guilty people act like that. Guilty people flee the scene. Guilty people don't give you a gun that they have. I don't have to prove why he did it. I don't have to prove that he premeditated about it. I don't have to prove that I don't have to bring his weapon. I'd love to have it. I'd love to match it to all this stuff, which my reason and common sense tells me in 61 that he shot every one of those. I know that. Y'all know that. You saw it on the video. I just don't have his gun to prove it 100%. But if you follow the evidence and you apply your common sense, maybe you'll get as upset as I did. So ultimately, this is supposed to be about justice for one person. The defendant is on trial, and obviously, if I didn't do my job, he should be acquitted. But I think it's really clear. Jacoby's the victim here. It is crystal clear who's responsible for his death. Let's get him found guilty and move on to you.
All right, ladies and gentlemen of the jury. Here's the jury charge. I'm tendering it to the bailiff. I'm going to ask the 12 of you in the jury box to step down from the jury box, follow the bailiff into the deliberation room. The two alternates, by law, only 12 people can be in the jury room. So I'm going to ask you if you'd be so kind to wait close by, hold vigil, and stand by as alternates. Thank you very much. We're in recess.
No. Phil Rice.
Here.
Thank you. All right, Rachel Sanders. Thank you. The Rance Group. I thought I saw somebody logged in. There we go. Thank you. All right, and then Latreia Storks.
Here.
There, see you there. All right, and Jermaine Montgomery. Okay, and then defense Owen Murphy. Or anyone representing Progressive Insurance.
I'm here.
Okay, thank you. All right, and Woodsmere Neighborhood.
Yes.
Thank you. And Catherine Quinn. All right, response. Matthew Wang.
Here.
Thank you. and Leo and Steve Eliason. Here. Thank you. And finally, John Jackson. Okay. And anyone representing Jiffy Lube or Teen Car Care. Okay, thank you. All right, we have a number of cases here today where both parties are present. All right, so I'm going to explain to you now our mediation process. So today here in court with us, we have some representatives of the Thurston County Dispute Resolution Center. These are mediators. And the reason they're here is that they're going to help you to mediate resolutions or settlements to your cases without the need for your cases going to trial. All right, now there are several reasons for that. I'm going to explain a few of them and explain to you some reasons that you might actually be better off mediating a resolution to your case. So here in small claims court, we found that people who resolve their own cases through mediation are usually a lot happier with the results they get. And at the end of the day, they go out of here a lot more satisfied than if their cases get resolved after going to trial. All right, there are several reasons for this. And the first I'm going to explain is that you have to keep in mind that the court is limited in what I can do. So when I hear your case, what I'm going to do is hear from both sides, the plaintiff's side, the defendant's side, and I'm going to make a decision about the case by applying the law that applies to your situation and coming to a legal conclusion to your case. Now, my process of doing that may not actually meet your needs. Okay, what I can do is listen to a case. I can enter a judgment in favor of one party or the other, and that's it. And that could only be a money judgment. Now, I'll explain a little bit more of that in a minute. So if you're a plaintiff and you're here claiming that the other party owes you some money, and assuming everything goes your way today, and you win in small claims court, what you get if you win is a piece of paper that says the other party owes you a sum of money. Okay, that's all you get. A lot of people, the first thing they ask me if they win their small claims case is, how do I get my money? I guess it's a natural thing to ask. My answer is, I can't tell you that. Right? If you want to get your money, if you win, you have to collect your judgment. Okay. Now, collecting a judgment that you get in small claims is a legal process. It's a different kind of legal proceeding than this, and it doesn't happen in small claims court. There's a whole process for it. It works a different way, and you may need the assistance of an attorney to collect a judgment. And if you go and get the assistance of an attorney, that's going to cost you money. If an attorney is willing to take that case for you, and you may find that whatever amount of money you win in your judgment is eaten up by trying to collect your judgment. And I'm saying that because I want you to keep these limitations in mind going into mediation as a motivation to mediate and settle your cases. Okay. So in small claims too, when I say I can award a money judgment, that means there are a lot of things that the court can't do. Okay, so for example, the court cannot order anybody to stop doing something, can't order anybody to start doing something, can't order anybody to fix anything, return any property, apologize, or accept payments over time. Okay, now I say those things because a lot of times people solve their own cases by taking those kind of things into account and settling their cases with those requirements between yourselves. Now you can do that if you want to agree to pay something over time, a little bit every month. You can do that and solve your case that way. The court can't do that for you, right? And there are some other reasons that mediation is good. When you take your case to trial in small claims, people come in here with expectations, and that's natural. Some people know what to expect because they've been here before. Some people don't. But basically, the way this is going to work, as I said, is I'll hear each side. I'll hear your side. I'll hear the other party's side. Now, at the start here, most people come into court and think, well, there's no way the judge is going to believe what the other party has to say. The judge is only going to believe my side of the story, and therefore I'm going to win. And I want, I want to make sure that you understand that that can be a mistake. I mean, you all learned as children that there's at least two sides to every story, right? And that's what court is for, to hear those sides. And it's entirely possible that I'm going to believe some or even all of what the other party has to say. Now, if I believe what the other party has to say and not what you have to say, then that's going to affect how your case comes out. Okay. Now, the other part of that that's related is coming into court. A lot of people think that they already know what the law is. Okay, I said I'm going to apply the law that applies to your case and the facts that I find to be proved and decide the case like that. Now, a lot of people think they know how the law applies, but they're not correct. Okay, small claims court is a place for you to come and get your cases resolved, but lawyers aren't allowed in here. So I'm going to assume that most of you, or maybe none of you, are lawyers. So you may believe you know how the law applies to a case like yours, but it may actually apply.
Out of track. Save all your breath. Yes, sir. Hold on, let her get. Yes, ma'am. Yes, sir. They all. I had left for time, but hold on. Yes. You ready? Okay. We now call cause number 23 CR 2059, the state of Texas versus McConnell Williams. Yes, sir. And you were here now. You were late today, and there was a bond forfeiture. Yes, sir. You have to be on time, you know. It'll never happen again. Subway leaves. Yes, sir. You know, we try to run it like a train station here. I understand. Then you're running down the track, which nobody can ever catch a train. You know, you're on your legs. You just can't do that. Yes, sir. And so we revoked your bond. So what was the deal today? I left at 5 o'clock. I got a 4-hour drive. From Baton Rouge? Yes, sir, from Zachary, Louisiana. Oh. I left at time, but I ran into traffic coming through Lafayette, bad weather. Yeah. And when you get by what it is, Benton, Louisiana. Yeah, it's been raining over there for a while, hasn't it? For a few days. Yeah, Baton Rouge, Louisiana. It's gonna get worse. But in Lafayette, it was pouring down. You can't see people riding with their flashes on. Okay, so don't worry about it. Yeah. Don't worry about it. Relax. You got here. Yes, sir. Okay, we're gonna take you out of the cuffs and yes, sir. I'm gonna but I promise it'll never happen again. Okay. If I gotta leave my house at 5:30 in the morning. Yeah, I'm gonna withdraw those earlier orders. Yes, sir. And you're gonna be back on your other bond. We can take him out of the custody. Thank you very much. And put you back on the bond. Yes, but you got some storms over there and gotta be careful. Well, they say it's pretty clear up now. They say it was supposed to come through Louisiana, but it didn't come through. And that's a blessing. Well, it's still got to, I think it's going to work for a few days. Yes, sir. Mr. Grove is your attorney. Have you had a chance to talk to him today? Okay. Y'all need to talk to see what direction we're headed in on all of this. Yes, sir. I also called yesterday because they didn't know if y'all was going to be open today. And I spoke with the lady. She told me y'all was open today. I just wanted to make sure I didn't want to make a blank trip. Thank you. No, we kind of work on, we're always juggling balls in this. We got a jury out deliberating on a trial. And then now we can take care of other things. But anyway, just have a seat. Yes, sir. But you're released. You'll be released from custody. Thank you, sir. Then we'll work with him here in a minute. So seeing what's going to happen in this case. Thank you. This is stuff right here. This stuff is young as one. Go longer. Or yes, the terrible sex. It's all with the thing with my most broad place. Good.
I was having the screen protector. I think mine's a surprise. Oh, yeah.
Mainly competent. So you get laid down. But also on the flying day, another, over the Friday, we have a plant this. And, we found it's another. He thought it was.
They both.
We'll all.
Yeah, he's gonna talk to David, here, just stand by.
Yes, sir.
And the gals.
What do that? Thank you.
Yes. Yes, sir.
I can let my fiance know.
Yes, yes, sir. You know.
You got one more in there.
Who's the other one?
It's Mr. Lewis, Ellie's trying to get a hold of Mr.
Yeah, we're trying to get his attorney.
This is something big. Wait, not right to me. Yeah. Oh, it's also until later.
Nice. Well, how?
If we don't wait, I can't it all done. This is what I all want. I understand.
Apply a different way, or it may not apply at all. Maybe a different law applies that you aren't aware of. And I guarantee you that if that's the case, the outcome of your case is going to be way different than you expect. Okay. Now I'm saying those things to you because I want you to go into mediation with an open mind and with an earnest desire to come to a fair and reasonable resolution of your case. Okay. You can maybe come out of small claims court with a settlement that you can live with. You go out of here and think, okay, that's reasonable. That's okay. I'm satisfied, right? And instead of running the risk that, you know, you believe you have an absolute winner on your hands and that the only judgment that could possibly happen is in your favor, and then it may go the other way. And people frequently are surprised after a small claims trial with how the facts are found and how the law is applied, and they don't get what they expect. All right. Now, the other thing I want to tell you too is I know that you're in conflict with the other party. It's a conflict that happened and a conflict that got you here. So before I turn the courtroom
to resolve your case. We're voluntary mediators, as the judge said, and we've been asked by the court to help you resolve the conflict that brought you here today. We're not judges or lawyers. We don't take sides, but we serve as a neutral third party to try to facilitate a discussion between the two parties and encourage you to try out different options or compromises, suggestions, where you might come to an agreement on your own that works for both of you. It may not be perfect, but it's something that it's an answer that will resolve your issue. If you're able to come to an agreement to your issue, we have a form. It's a small claims agreement, small claims court settlement agreement form that the DRC and the court worked up, and we will help you fill that out, detailing your agreement. And if once that is done, the DRC will send you copies electronically after court, and you will electronically sign them and get them back to the DRC. The mediators will also sign, and that agreement will be submitted to the court as an official settlement of your claim. So when we join you in the breakout room, you may have to wait a few minutes for a mediator to get to you, but we would encourage you to exchange information, have some dialogue, and toss around some ideas about how you might resolve this with the help of the mediator and without having to go to trial, where the judge will make a decision based on the law. If you're able to reach agreement, you will be able to leave the courtroom. But if you're unable to reach agreement when you're in a mediation session, we would encourage you not to leave Zoom. You can leave the breakout room, and once you push that button, it will pop you back into the court with the judge so that your case may be heard. So that's our process. We encourage you to mediate with us in good faith, and we'll ask the clerk of the court to begin placing members of the same case in a breakout room with the mediator.
All right, so that will terminate that case and you're free to go whenever you'd like. And then the next one-party case was the Woodsmere neighborhood versus Catherine Quinn.
Yes.
Number 39196, final call for Catherine Quinn. All right, no answer. Thank you. All right, check here and see what the service looks like. All right, so from Woodsmere Neighborhood Association, I'm looking in the court file for the proof of service of the notice on Miss Quinn.
Proof of service. I'm sorry. What do I need to have?
Proof that the lawsuit has been served on Miss Quinn.
Oh, yes, I have the paperwork here.
Okay. Can you file that paperwork with the court?
I thought it was filed on May 6th. Is there another? It says filed May 6th, 2025.
Okay. Yeah, I do have some documents that were
Okay.
on May 6th. But
That's not the right one. I'm sorry.
I just don't see any. I see a copy of a letter that was sent to her.
Yes.
But I don't see proof that the lawsuit was served on her.
I have, I don't know if this is right. It says sheriffs of Thurston County is. It says Derek Sanders, sheriffs of Thurston County, state of Washington, do hereby certify I received the notice of small claims. Is that what we're looking for or no?
It could be. Is that something you want to file with the court?
Yes, I'm sorry. I thought that was filed with the other paperwork. Okay.
Okay. All right. I tell you what, I'll set this case aside and you can file whatever documents that you have that show service, and we'll come back to this case once we receive them.
Okay.
Okay. All right. So we'll set that aside for the moment. Okay, and I believe, is that all the one-party cases, Trace? Okay, and then there was a no-party case, two no-party cases. So let's start with Edmondson versus Washington, 39150. All right, so neither party appears to be present. I'll make a final call for Cameron Edmondson and a final call for Ebony Washington. All right, no response. The claim will be dismissed. Jace. All right, and the other no party case is Numson versus Evergreen Car Wash. That is number 39181. And Chase, I think we got we got a motion to continue. Okay, it doesn't appear that the defendants have been served either. I don't see that, so we'll grant the motion to continue and the plaintiff can select a trial date with the clerk. Okay. Number 9 is Jackson versus Team Car Care Jiffy Lube. All right, John Jackson.
Yes, sir.
Okay, would you mind having a seat there at the table, Mr. Jackson? And then who is here from Team Car Care Jiffy Lube? All right, would you mind taking a seat at the other table? And what's your name, sir?
John Allison.
Allison?
Allison.
Okay. Mr. Allison. All right. And this is case 39204.
Do you need my letter authorizing me to represent the company?
I might, don't. Can't answer that just now, but I might.
Fair.
Okay. All right, so Mr. Jackson, you're the plaintiff here. You initiated this case against Jiffy Lube. Okay. All right, so I'll explain to you, and then this will be the benefit for anybody else, I guess, if they're here, the way this will go. So what I'll do is I'll swear the parties in, and then I'll hear the evidence in the case. So what I'll do is hear from the plaintiff first. You'll present your case, your testimony, any exhibits that you filed by the filing deadline. And if you have any witnesses, I'll hear from them as well. So after I've heard from the plaintiff, it'll be the same thing for the defense. I'll hear any testimony, consider any exhibits that were filed in time, and any witnesses who may be brought to testify. After I've heard from both sides, I'll make a decision. And I'll tell you what that decision is and why I made the decision that I did. During the time that the other party is telling me their side of the case, I'm going to ask you to just let them do it. And even if they say something that you don't agree with or you don't believe is true, don't interrupt the other party. Keep in mind that if, I know there are two sides to the story. I know you don't agree. And if they say something you don't agree with, you either have already told me your side of it, so I already know, or you're going to get to in a couple of minutes. So just don't interrupt them. And then I may need to ask questions just so that I make sure I understand the nature of your claim, the nature of your defense. So I may from time to time kind of jump in there with a question or two. And I may also do that to just sort of keep things focused on the issues and facts that I need to know to decide the case. Yes. Okay. All right. And to be clear, you'll each get one turn. So I'll hear from plaintiff, hear from defense, and that's it. All right. We won't be going back and forth unless I have questions that I need to ask. So that happens sometimes. All right. Can I have you both raise your right hands, please? Do you both swear that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth? Yes, sir. Okay. All right. Mr. Jackson, sir, you are the plaintiff. You get to go first.
Do I have to say anything?
You don't.
Okay.
Unless you want to.
Okay. So, so back in February, Your Honor, I had a transmission failure regarding to my truck. My first instinct was to, just take it to the closest shop to get it repaired. Because at the time I was attending school, out of state. And upon inspection and, observation of the repair of the transmission, I was informed by organization Midas that the improper or wrong transmission fluid had been added to my transmission, thus resulting in transmission failure. And that's pretty much what brings me here today, Young.
Okay. So your claim is that the transmission in your truck was damaged because the wrong kind of fluid was put in there.
Yes, sir.
And that damage amounted to the amount of your claim, which is $7,017.
Yes, sir.
Okay. I'm gonna ask you a couple questions about that. All right, so you took it to Midas to get fixed.
Yes, sir.
Okay. So can you explain to me how the wrong fluid got in there?
Well, I had the truck for about maybe a year up until this point. And the only personnel that has had done transmission work had been Jiffy Lube at that time. So it wasn't giving me any issues beforehand. And I didn't think at the time, I didn't think that was any wrongdoing by Jiffy Lube. I just wanted to get, my transmission fixed at the time. So I just took it to the first shop, and then, that's what I had to tell them, that it was the wrong transmission fluid had been added. So there was no other services regarding transmission done to my truck.
You had the truck for about a year.
Yes, at that point.
And this is what kind of truck is this?
It's a
Chevy Silverado?
Yes, sir.
2015. You bought it used then?
I bought it used from it.
All right. Is there anything else you want to tell me about it?
Not that nothing that jumps out at me as far as like the mechanical aspect of the unit. I was told by Jiffy Lube that the color, or what they had received from Midas, the color of the transmission is a possibility that it just turns to that color over time. There's no way to really prove that that we put the wrong transmission fluid in there. And with you going to Arizona, it wouldn't make it that far. That's not necessarily true. Even though it's the wrong transmission fluid on it, it's still transmission fluid. It just does damage over a longer period of time.
How long did it take for the damage to be apparent?
I'd say, well, from when the service was done up until when I took it to the shop, I'd say about 6 months. I'd say about 6 months. And there was no, upon the inspection that Jiffy Lube had done, there was nothing, if it was wear and tear, there was nothing told to me in the report that hey, the transmission is, and such.
And the documents you submitted as part of your case, it says the mileage on your truck was 101,000 miles. All right. Okay, make sure I'm not missing it. Okay. All right, is there anything else you want to tell me before I hear from Mr. Allison?
Oh, no, not at all.
Okay. All right, Mr. Allison, you want to tell me the Jiffy Lube side of it?
Everything he told you so far tracks as far as when it occurred. At time of service of his vehicle, there was no internal transmission inspection. It was a preventative maintenance fluid exchange only. We also serviced the transfer case at that same time. Both used the exact same fluid. Both were given the exact same fluid at the time. And it is the fluid that meets the specifications of what Chevrolet requires to go in there. To what he said, the argument on the color of the fluid, our argument was we were able to inspect the vehicle at any point. We weren't given the ability to look at anything before services were repaired and done to evaluate if there was by chance fault. The only way we could confirm that we used the right fluid is that the transfer case was given the same fluid and it did not fail in those 6,000 miles. But the appearance of the fluid it's just not something I can really base anything off of. But I did bring, and I believe we've submitted already, the documentation showing that we use the appropriate fluid. It's documented as the appropriate fluid. Based on that, we just don't see how what we did could have caused it to fail.
All right, is there anything else you need to tell me?
No, sir, nothing relevant. Or irrelevant for that.
Okay. All right. Well, I mean, I understand the nature of the claim here. I mean, that part is pretty straightforward, but in order to, prevail and recover, you have to be able to show by preponderance of the evidence that the actions that Jiffy Lube took were a proximate cause of the damage to the vehicle. And I mean, there isn't any evidence here that I can conclude from that I can make the conclusion that occurred and that Jiffy Lube is responsible. I know based on what you told me, what both parties have told me, that there was a service done. That's all I really know. There's no evidence whatsoever about causation. How did it happen? We know that the service happened, and we know that later in time there was damage to the transmission and a transmission failure. That's all we know. We have to know what caused that, and then we also have to know if it was negligent to take whatever action it was that caused that. So there's really an absence of proof or absence of evidence here that I could make a finding. So as a result of that, I'm going to have to enter judgment in favor of the defense.
We're going to call all the parties and receive the verdict. Thank you. Stand by.
All right, I've reduced that to a written judgment, and both of you can have a copy of that judgment. And I'll conclude your case for today.
Six on the calendar, it's also ready for trial.
All right, thank you both. All right, then next will be Latreia Starks and Jermaine Montgomery versus Owen Murphy and Progressive Insurance. All right, are you there, Ms. Starks?
Yeah, good morning, Your Honor.
Good morning. And then Murphy, Owen Murphy.
He's not here. He wasn't served.
Okay. And then you're Miss Medea?
Yes, with Progressive.
Progressive. Okay, gotcha.
And Your Honor, Jermaine Montgomery's my husband. He wasn't able to make it because he had to work. Just so you know.
All right, Ms. Starks, so you weren't able to serve Mr. Murphy?
Yeah, so Mr. Murphy did a hit and run on my car, and so his car insurance is Progressive. There was no way for me to get his address because they won't give that to me due to confidentiality. And since they were the ones who made the decision to deny my claim, I brought the suit against them and just put him on it since he was a part of the accident.
All right. So, Ms. Starks, I see this sort of thing from time to time, and you can't sue the insurance company of the person who hit you.
If they made the decision, why can't I?
The person who hit you may be responsible for any damages that they cause, but the insurance company has a relationship with that person, not with you. They're not obligated to you for anything unless you're claiming that they did something to you, like drove the car that hit you. But it doesn't sound like that. It sounds like you told me that Mr. Murphy did that. So the fact that Mr. Murphy has insurance with another party doesn't allow you to sue that other party.
I guess my understanding was, or my thought process was, since they made the decision about like him not being at fault. And if he was at fault, they'd be the ones paying. That's why I put them on.
Yeah, and that's a common mistake, but that's inaccurate. That's not how the law works, and you can't file and maintain a lawsuit against somebody else's insurance company because the insurance company might be responsible for paying it. So I'm not going to allow you to maintain a case against Progressive, and I'm going to dismiss them out of the action. But since you haven't gotten service on Mr. Murphy, I'm going to give you the option of continuing your case for trial at a later time so you can serve Mr. Murphy, or you can dismiss your claim. That's up to you.
Am I able to get his information from his insurance company?
I can't answer that question.
Okay. I guess I'll just continue it.
Okay. I want you to. All right. So Progressive is dismissed from the action. And I want you to contact the court clerk's office and select a new date for your trial, and then you can get service on the defendant, Mr. Murphy.
Okay.
Okay, so Ms. Medea, Progressive Insurance is dismissed from the case.
Thank you.
So just in this particular, Leo and Steve,
Mhm. Oh, for
for mediation.
For mediation, okay.
They are.
Okay.
Leo and Steve.
Yeah, Leo and Steve, you want to go with Mr. Shiflett there? Okay. And did we get anything from that Woodsmere case? Did they send anything in?
Right now, I did message the email. They submit stuff to.
Mm-hmm.
Right now.
Okay. So we'll hold off on that. All right. So then we're still mediating the others.
Case number 5 has reached the DRC agreement.
Mm-hmm.
Submission
We call 22-39014, the state of Texas versus Stephan and Jail, present with his attorney and the state's attorneys. The jury has called two bells indicating they've reached a verdict in this case.
Don't wait outside. I'm sorry.
Yeah, we got, I'm sorry, something has just come up we have to take up before we bring the jury in to take this verdict. Okay, go ahead. What state say?
So Judge, I have first submitted notice back on August 6th of 2024. Given notice of intent to enhance his punishment under 1242F of the Texas Penal Code. It is my intention, if this is a guilty verdict, to read the remainder under paragraph 2 of that notice, like we would if it was a part of the indictment. And further presents that before the commission of the primary offense, the defendant was finally convicted of the felony of assault of a public servant on February 7th, 2017, calls number 1165 in the 21st District Court of Lee County, Texas. Gives him an opportunity to enter a plea of free or not true.
I object that it's not part of the indictment, even in the indictment, Judge. It was just given notice and that, to me, that's different. It has to be put on through evidence in reference to his father. It's not part of the indictment that was presented to the jury, or part of his record at this point.
My response to that is, an indictment is just about notice. So if we give someone the intention that if we give them notice in this written form, it's considered proper. We do it all the time.
I understand.
Actually, it was at the time, this was at the court's behest when we tried this case first time.
What's the
Well, we never got to that.
what's the date that you're using? Because I've got
My file mark date for this notice was August 6th of 2024. That was me amending the prior notice because I think there was a mistake in the number of district.
okay, this is the first amended notice of state's intent to enhance punishment.
Correct, Judge.
You've received that, discussed this with your client a year ago.
Yeah.
Okay, you're on notice.
On my notes.
And it's formally filed. I don't see where there is a formality that needs to be made where he has to plead true or untrue. I know the way we do things on the enhancements on paragraphs that enhance subsequent paragraphs to the primary charge on indictments. But the key is given fair notice and of what the state intends to prove. And at the end of the day, he can stand by the presumption of innocence, and the law states that your burden is to prove it. Even when you plead true, when a plea of true is done, supplemental evidence is made to support the plea. But the defense acknowledges you're on notice. You've been aware of this first amended notice of the state's intent to enhance punishment with a prior felony of assault of a public servant on February 7th, 2017, and cause number 1165 in the 21st District Court of Lee County, Texas, which the state intends to present before the jury and presumably ask for enhancement of punishment. If the defendant is found guilty, punishment can be enhanced to no less than 15, nor more than 99 years confined in prison or life in prison.
Yes, sir.
And defense acknowledges that notice of those allegations have been received, and you've discussed that with your client. Okay. Is that true, sir? All of this, you're aware that that this prior conviction can possibly be presented before the jury, which would enhance your punishment range. And you've discussed that with your attorney. In the event you're found guilty, if it's not guilty, you're walking out of it. Okay.
In theory,
In this area somewhere.
but he's got other pending charges.
Oh, that's right. We've got a couple of other indictments pending. But that would end this case if they're not guilty. All right, we've got a verdict. Let's bring the jury out and receive the verdict. Thank you. And thanks the alternate jurors for holding vigil. Thank you very much. And the record shall now show that the jury is in the courtroom. Mr. Jones, I believe you are the jury foreperson.
I am.
And I'm going to ask you a couple of questions. Number one, the court has received a message from the jury that the jury has reached a verdict in this case. Is that so, sir?
Yes, sir.
Is this a unanimous verdict? That is one that is agreed upon by all members of the jury?
It is.
Do any of the jurors disagree with your foreperson's representations? No disagreement. It does appear to indeed be unanimous. If you would be so kind, pass the documents to the bailiff. You may be seated. I will review for proper form and publish the verdict. And the defendant shall rise. In cause number 22-39014, the state of Texas versus Stephan Rayon and Gil. We, the jury, find the defendant guilty of the offense of murder as charged in the indictment signed by the jury foreperson. The verdict is received. It is made a part of the record for all purposes. Ladies and gentlemen of the jury, at this time, I have accepted your verdict finding the defendant guilty of the offense of murder as indicted in this case. And that brings us to a close of phase one of this bifurcated two-part trial. We will now proceed with the punishment phase of this trial. And once again, let me repeat, you're still under the instructions that the court has given to you up to now. Let me see lawyers, please. Thank you. Break for lunch. Can all of you return back? Is 1:30 going to be enough time? It's 1:23 now. That's a little over an hour. Is that good? Okay, thank you. And we'll wait on you. You're coming in from lunch a little tardy. That's all right. Please remember the instructions the court has given to you. We'll see you all back at 1:30. Thank you very much. Everyone else remain seated while the jury exits first. Thank you. You get this, you can make it win. Oh, okay. Anything to be brought up by the parties at this time, state or defense? We're in recess till 1:30 on this case. David, let's get your stuff done. Thank you.
No, I'm totally fine. Like, love it, love it, love it. Can I ask why?